All right, joining us to discuss the controversy following the judgment of Justice Obiora-led panel of the Appeal Court in Akure is Professor Kazeem Olaniyan of the Faculty of Law, University of Lagos. Glad to have you join us, Kazeem.
Thank you for having me.
Good, fantastic. Now, this won't be the first time there are different interpretations to a judgment of the court. What's your sense of that?
Well, politicians will continue to be what they are because they have a way of making simple things difficult. We have all seen the way the tribunals have been handling petitions. Issues are consolidated so that the court will have the opportunity of delivering one judgment, and that will be once and for all. But what you find in many instances, especially the Osun State election, is that issues are splitted between different parties, the interested party and their proxies. And nobody makes effort to consolidate from the part of the party suing. And if the court does not so much to consolidate the issues, the chances are that judgment will be given in the manner in which the Osun State election judgment was delivered in the Federal High Court. So, the failure to consolidate meant that two separate judgments were there to be appealed against. That could have been cured even in the Court of Appeal by the parties or one of them making an attempt to consolidate even at the Appeal Court. But as it turned out to be, each of the parties was trying to gamble. The PDP, for example, believing seriously that maybe the appeal, which led to the judgment of February 10, was possibly going to be in its favor, thought that the best thing is to get rid of the other appeal. Truly, it was the APC that appealed. But if what the APC failed to do was to compile record and all of that, and you seriously desire that there should be one Court of Appeal judgment to resolve all issues, then you could have made effort to compile the record, since the record was there, was available for everybody. And unfortunately, that was not done. Instead of doing that, the PDP also went to Court of Appeal to get that appeal struck out. And they were jubilating. But some few days later, the other appeal was decided, and the other appeal returned the parties back to status quo ante. Status quo ante simply meant that they will go back to the situation.
Let me come in there. The question that will be raised by watchers, interesting parties, is why can't courts make it clear the judgments, or make clear the judgments in such a way, that it leaves room for only one interpretation? I mean, take the case of the labor. Why can't the courts make it clear, make the judgments clear in such a way that you only have one interpretation?
Well, the rules make provision for that. It's called consolidation. And you've seen that that is the pattern in which the tribunals deliver judgment on election. That is what is expected if parties are really seeking the truth and justice instead of relying on technicality. It is very easy for somebody to say somebody appealed one and did not prosecute the other appeal, okay? But both of you are parties in the matter, and the justice of the matter actually is to make it possible for the appellate court to deliver just one judgment. So if you look at what has happened in this motion to release, the motion to release, you must know, was not filed after the judgment of February 10th. It was filed on 23rd January, which means that that motion was already before the court, before the judgment of February 10th was delivered. If both parties were actually desirous,
all right, let me come in again there.
ending the case with one judgment.
Let me come in again.
No,
there.
let me finish this. Let me finish it.
Okay.
Yes. So if both parties were actually desirous of ending the matter in the Court of Appeal with one judgment, either party could have done something about it. What we had was one party applying to the court to dismiss the other party's case because it has not done what it should do. And that thing that the other party should do is not beyond the party who applied for the matter to be struck out.
Okay.
And by the time the February 10th judgment was given, that party had now done what needs to be done. So it was a gamble. It was really a gamble that was taken.
Okay.
If the judgment of February 10 had not favored the APC, by now they would have been struggling to appeal to the Supreme Court. They wouldn't even be talking about the one that was struck out.
Okay.
But the application to release was filed not after the judgment, but before the judgment.
All right.
So nothing new has happened.
Okay.
For anybody to say the situation needs to be re-examined.
Okay.
The same argument, the same academic argument.
All right.
The same academic argument regarding a federal high court judgment favors a court of appeal judgment is what the politicians have been boring us with.
Okay.
Okay, and the position is very clear.
Okay, fine.
You can't try to invalidate a court of appeal judgment because of a federal high court judgment.
Okay, fine. While I'm sitting listening to you, I'm wondering, politicians would do what they need to do. What they want to do, not what they need to do. I'm wondering, is it possible, I don't know, that the courts or the judge or justice could ask for a consolidation of this? I'm just wondering whether that is possible. Then you will also answer this question.
Yes, indeed.
When the court struck out, the court says it was struck out for non-diligent prosecution, concerning APC. What is the court effectively communicating to APC when it says non-diligent prosecution?
Well, you see, when a matter is struck out for non-diligent prosecution, whether in the High Court or in the Court of Appeal or anywhere, there is a leave to apply to released, which was what APC tried to do. Okay? Unfortunately, the Court of Appeal did not take that application until after the judgment of February 10. And the Court of Appeal would not want to be delivering two judgments on the same issue. So that is why the Court of Appeal said that granting the request of APC, apart from the fact that it was not convinced with the excuse given by APC, that granting their request would mean that they would be sitting down to review their own matter, which is not right. It is only the Supreme Court that can review decision of the Court of Appeal. So, to ask your question specifically, who has the role on consolidation? Consolidation can be done suo motu by the court itself. That is, if the matters are before the court. In the case of the Federal High Court, the learned justice who delivered the two judgments had the opportunity to consolidate. If he had suo motu consolidated the two judgments and delivered them, there would have been no need for the controversy that we are in. Okay? Failing to do that, one of the parties should have asked for consolidation. But you see, it's a gamble. You keep the cases in the court for as long as you split them. We saw what happened in the Rivers case. For as long as you split the cases, you will continue to have hope that maybe when they decide this one, it will turn my way. And so from all indications, it's a gamble.
And
this time, it doesn't appear to have worked.
All right.
He didn't pay. This time around, he really didn't pay. The Court of Appeal is simply telling them that go and face your trouble. I don't want to sit over this matter again. I am functions official of it. So even if you have convinced me, even if you have given me a reason for relisting, after the judgment of February 10, I am not, or we are not, willing
to revisit it.
So it's not anything for anybody to be excited about. Nothing new has happened.
Okay.
The position remained the way it was on February 10, and the Federal High Court judgment, the second Federal High Court judgment, the one that APP filed, well, maybe as a judgment, it was on point until the Court of Appeal decided February 10. After February 10 judgment, it becomes academic.
All right, we'll leave it there.
What you have is a Federal High Court judgment against a clear Court of Appeal judgment.
Thank you so much, Professor Kazeem Olaniyan of the Faculty of Law, University of Lagos, for being on Newsnight.